Thank you for joining Tulsa Christian Businessmen, presenting Judge Bill LaFortune. Video sponsored by Tulsa Regional Business Alliance. The Tulsa Christian Businessmen meet every second Thursday of the month from noon to 1 o'clock at the Bynum Hotel on 41st near Garnett. And now, Judge Bill LaFortune.
LaFortune's grandfather, Joseph LaFortune, was an oil executive and noted philanthropist in Tulsa. His uncle, Jay LaFortune, was mayor of Tulsa from 1970 to 1978. Bill has served as district attorney of Tulsa County, as a special judge for Tulsa County, and as assistant attorney general for the state of Oklahoma before his current role as Tulsa County district judge. Now, he's got some pull right now, because the last thing I'm going to tell you is Bill's nephew, G.T. Bynum, is the current mayor of Tulsa. Would you give a warm welcome to my friend Bill LaFortune?
Afternoon already. It's a great honor to be here. I've had the pleasure of speaking with you all before, and it's always a pleasure. Old friend Dave Leggett's over there, and I remember Dave was the first one to introduce me to the Christian Businessmen Association years ago when I was first running for mayor back in 2001. And you all, I believe, were meeting over at the Fountains Restaurant, if I recall correctly, at that time. And Dave was the one that introduced me to all of you, and I really enjoyed being able to give my testimony as a Christian to you then. It hasn't changed. And get to meet a lot of the people that are in this room right now. So I have some history with this group, and I really admire and love all of you, and love the opportunity to be able to speak to you as well. You mentioned my grandfather. You know, those that have been around me and followed my campaign as mayor back in the day, I have heard the story so many times they don't want to hear it again. I'm not going to tell it again, but it's a fascinating story about my granddad and how he came to Tulsa. That's who the park is named after, and his legacy. He had 4 children that had 21 grandchildren. I'm one of the 21. And G.T. Bynum is actually the son of one of those 21, Susie LaFortune Bynum. She was the daughter of Robert J. LaFortune. So he's actually my second cousin, because Susie is my first cousin. But I'm very proud of the legacy, but it really goes back to him. He was a rags to riches story, a classic American story that you all are familiar with. Many in this room have lived that same story. You didn't have anything at all to start with. And through your hard work and through your business acumen, etc., he came to Tulsa with nothing back in 1990, nothing. But he'd heard it was a great town, maybe a young man could make a living here. And that's why he came. And sure enough, he did over the years. And what he gave to us as his grandchildren wasn't just money. There was too many of us. I always tell people I love my job as a district judge. I've loved every job I've ever had, and I love working. I don't hunt. I don't fish. I don't golf. I love what I do. I love the law. I love the job I have now. It keeps me busy, I guarantee you, all day, and usually every night, and the weekends too, in reading to get ready for the next day, and reading briefs and reading cases and trying to do if you don't do that, you're going to make bad decisions. You make bad decisions, then the Court of Criminal Appeals that reviews, I've got someone that reviews my homework every day, and it's them. And there's nothing more embarrassing for a judge than to see something and write it back from them saying you did the wrong thing. And that's what happens. People will ask me a lot of times, and before I get into that, let me do this. I became a district judge back in January of 2015. I think last time I was here, I talked about just the daily, what we do daily, so I'm not going to rehash all that because you all heard that last time I was here. But in 2.5 years, I counted up how many felony trials. I love being in trial. To me, it's my chance to get to see the citizens. Otherwise, I'm sequestered with lawyers all day, which is fine. So if you don't like lawyers, you shouldn't be a judge because you're going to be with them all day, every day. But the jury trials, we only have about half the number of jury trial weeks we used to have because of the state budget. I know you don't want to hear about the whining about the budget. I'm not whining about it. I'm just telling you the reality is that when I was coming up as a young prosecutor, I was telling the Tulsa County Republican Men's Club yesterday, we had a panel of judges, and I was one of them, that back in the day when I started in 1983 in the courthouse as a third-year law student working for then District Attorney David Moss. As I said to the group yesterday, and I'll say it today, David was a Democrat, but David was a faith-filled Christian and a good man and a wonderful mentor. But that was my first taste of the courthouse, and I loved it. And most of my career, except for the 4 years as mayor, has been in the courthouse in one capacity or another. And I love it's just like being home for me. So when I go from, any job, as you all know, you've heard this old adage, you should have a job that when you get up in the morning, you're excited to go to work. And it doesn't always happen, we all know that. But I am. When I get up, I'm excited to go do this job because I love this job. And I have this full-time criminal felony docket. And I love that. And right now, we just have one of our judges, district judges, Dana King, was just appointed to the Court of Criminal Appeals, which leaves an opening for a civil docket. And so they go in seniority of judges, and the two above me in seniority would be Judge Mussman and Judge Caputo. And I think both of them would want to keep their criminal dockets. They are like me, they like doing what they do. And so I would have the opportunity to go to a civil docket, and I haven't told them I'm not going to, but I don't think I'm going to. I really love the criminal law. Yeah, it's not the most glamorous, and I'm not with the silk stocking lawyers every day by any stretch. But to me, it's cutting edge, it's exciting, and there's just new things every day that happen there that I don't think you really get with the civil docket. So I counted up how many felony trials, major felony trials. We don't try cases that are very serious. The first trial I ever had was not that serious. It was a second-degree burglary of a mini storage where the guy was caught red-handed. And so but from that point on, it's been all murder, manslaughter, child abuse, armed robberies, home invasions. Mostly murders and child abuse, quite frankly, though. Robbery with firearm cases. So those are the ones we try, because those are the ones that carry the most years, and those are the ones where the defendants want to exercise their right to a jury trial, which all defendants have a right to do. I have presided over 54 major felony trials since I started, so 2.5 years. And the sentences that I've sentenced, what happens at the end of a jury trial, the verdict's reached, and we usually have to pass it for formal sentencing. The jury will tell us how many years they want to give someone, or life without parole, whatever it might be in a murder case. See, in murder, there's only two choices for a jury if they find the defendant guilty. Life without parole, if it's a non-death penalty, which, as you all know, very rare. It's either life without parole or life. That's it. And so when you do a lot of murder trials, you're going to see a lot of life without paroles and a lot of life sentences. So in those 54 major felony trials, I have sentenced 13 persons to life without parole, 26 life sentences, 1,755 years of prison time in the Department of Corrections, 7 years, 30 days in the Tulsa County Jail. So, and that does not include the sentences that I have imposed pursuant to plea agreements, or one other category, which are called blind pleas. Blind pleas basically mean that a defendant does not like what the offer is and plea negotiates with the state. They don't like it. It's too much time. They're saying, hey. And they also say, I don't want to get in front of a jury because 12 people just like you all are going to be looking at me and seeing these horrendous facts, and I know what they're going to do to me. So let's see if the judge will maybe give me a lighter sentence. Well, it doesn't always work out that way, and you'll see that. And you try, when I was new, right, they want to test me out. And I've had some DUI manslaughters, and every case is different. You got to look at the facts, got to look at the circumstances, and determine what a sentence should be for anybody. But, when you kill somebody, even if it's a DUI, especially if it's a child that's killed, that, to me, I look at that. Not that us older people don't deserve the same sentence imposed for if we were killed by a drunk driver as a child. But when children are killed, to me, that's just a devastating situation and deserves a tougher sentence, a lot tougher sentence. And I will give life sentences out on blind pleas on those, and I have, and my record would show that. And I'm not saying that this I'm proud and I'm a super tough judge. I do what I think is right based on circumstances. And I was telling the group yesterday, one thing that we see is these property crimes tend to get kind of pushed under the radar. And if you're a young assistant prosecutor and you come to the office, you want to be trying larcenies, shoplifting, and things like, you want to be trying murders and rapes, and you want to be a big prosecutor as soon as you can be. And so they plead out. There's a lot of plea bargains. There's a lot of plea bargains. Sorry, there you go. A lot of plea bargains that go with those types of crimes. But what alarms me, quite frankly, when I see them, and I do, and the longer I'm there, the more I do, and the more the same names seem to be coming back again and again. So if I see a guy that's charged with burglary second degree, but he's got about 13 prior convictions for possession of stolen vehicle, larceny of this and that, then I start to say, there is a real public safety issue. The problem is with the Department of Corrections, and I'm not here to blast anybody, quite frankly, but realities are realities. They let these guys out really quick. I just did a blind plea on the non-murders case. I'm talking about property crimes, etc., drug crimes. They're not going to stay very long. I had this guy. You all remember that case with the little baby died in a shack, and there was a girl in there, the mother, who was using meth all day, every day, and there was an old guy that took her in, and he was cooking the meth, and they do the meth together, and this little baby had to live in this shed with nothing in it. It was just a horrendous situation. Needles everywhere, etc. Well, they both did blind pleas. And but when I looked at this guy, they do these pre-sentence investigations, these PSIs. And these investigations will tell you the background, particularly the criminal history. And this guy had a criminal history that went back to 1980, whatever, or late 70s. And he'd gotten a 20-year sentence back in 1980 something, and he was out in 7 years. He got a 7-year sentence later. It was a continual crime pattern, this guy. He was in for a year or two, out, and then this thing comes up. And so he got life, for sure. And he didn't like it. Boy, he thought that was just too harsh for his participation in that event. And I said, listen, you both have separate life. You both are equally culpable. He didn't like that because she got a little bit less than he did. And he thought, well, that's not fair. Because you said you were equally culpable for different reasons. She for bringing this child. Now, the child died not from the neglect, which is why this was not a murder case. They had a lot of high profile on this one. The child died from SIDS. So the medical examiner said the cause of death was sudden infant death syndrome, and was not from the neglect, not from being around all these needles, not from living in a shack. And so that's why the DA didn't file it as a murder case. But as I heard all the facts, it was very interesting because this guy, as a form of punishment, he liked to swaddle this 6-week-old baby so tight the baby couldn't breathe and would start crying. And then he would, put this baby in a prone position to punish it, 6 weeks old, right? And mom was so high, and she went off to go buy some pseudoephedrine or whatever while he was there. In all the circumstances, once I heard him, even my court reporter, and she's been around, she was with Judge Gillert, who I took over for when he retired. She's seen it all. And she was like, I don't know why they didn't charge that guy with murder, because SIDS has certain characteristics. They don't know, right? They don't know the cause. But there's certain things like smoking a lot in front of a child, or laying the baby down in a prone position too much. And that's what they were doing. So I'm thinking, isn't it an interesting coincidence? But the last time she saw the baby alive, and she went to get cigarettes down the street and left the baby with this guy, is that he was swaddling it so tight and it was crying, and he was putting it down to punish it in a prone position. But the state has to prove things beyond a reasonable doubt, and that's the way that works. So that was just one example of what a blind plea situation is. They're just throwing themselves on the mercy the court. One thing, I'm going to take some questions because I do have to get back. I have a jury trial. I've got to give instructions and closing arguments at 1 o'clock straight up. But and I didn't think it was going to go this fast, and I'd have to rush, but it went faster than I thought. And I was sitting there this morning with the jury thinking, I'm not letting Ted down. Ted, you don't let down, right? And I'm not going to go to Judge Drummond or someone and substitute him. But we're going to get this done. So somehow I was able to manage it and say, I'll be back at 1, but we're taking a break from 10:30 till then. So, which is fine. But, so that's just another trial. This one is a 6 counts of child sexual abuse of a child under 12, this case. And so we're sitting there yesterday, and we have a little girl testify who's 9 now, 7 when the abuse happened. And I'll tell you, that's a tough deal. But I've been doing this a long time. When I worked for David Moss, when he first hired me, I started in juvenile court. And I handled all the child abuse and termination cases for a full year over there. But that's what I'm doing today. One of the things I wanted to touch on real quickly, something that has been somewhat in the press over the years, and I don't want to get into the subject to have anybody 3 days from now say, well, the judge told me I could do this stand your ground thing. But I want to talk about stand your ground law real quickly, and then I'll take some questions. It's an interesting topic, and the reason I want to bring it up is it comes up a lot. We have the stand your ground law in Oklahoma. And basically, it allows a defendant who may be charged with murder to claim immunity. So the difference between stand your ground and self-defense, really it's just an extrapolation of self-defense. But stand your ground is different in that it's supposed to grant someone immunity from the get-go. And if the DA doesn't think so and files anyway, then the defense attorney has to raise it before trial and get a ruling from the judge, and we have to have an evidentiary hearing on it. And then they can appeal it before trial. And then you wait. And the reason I brought it is I had this on a pretty regular basis. And, the law basically is if somebody breaks in your home, breaks in your car while you're in it, and or your business, any of those 3 situations, then, and you have a reasonable belief to fear great bodily harm or death from this person, you can use deadly force against them, and you should be immune from prosecution. Now, all of those facts are unique to that's the law, but the facts are unique to each case. So the DA is going to evaluate them each time. But I've had them, I've got one up on appeal right now. They passed a law after the original law that allowed people to use stand your ground defense of themselves or others in non-home, non-business, non-car situations. It says if you're in a place you have a right to be, you're not violating the law, and you've got these same reasonable fears, then you can use deadly force. Well, this case I have is, it's on appeal. I'm not going to comment a whole lot about it. It's all public record, what I'm telling you. This was a domestic violence. And so domestic violence between people that live together, husband and wife typically, has not always been applied and does not apply, in my opinion, as the law is written today. Now, the defense attorneys in this particular case wanted me to rule that it does apply, and they were trying to use that statute. You're in a place you have a right to be, you're in reasonable fear, why can't it apply to a domestic murder, domestic violence murder? And it was a 32-page opinion I wrote. So I'm not going to obviously go into all of that, but I said it does not apply as our law is written now. And so that's on appeal. So if somebody's going to make new law, I'm going to let the appellate court do it. I'm a constitutionalist. I am a person who looks at the law and tries to construe the law and not make new law. I got a big enough job just doing that. I don't need to be making new law. Thank you. Because I really strongly feel that. Now, whether the law is right or wrong, I took an oath to uphold the law, and all public servants do. And that's my job. So I love what I'm doing. We've got some elections. I can't talk much about them because tomorrow is the first official day I can. So I'm going to defer for another day. But next time I'm here, I might try to. But there's all sorts of strict rules on judge elections that there are not on partisan races. In other words, you can't even raise money on your own. You can't speak on your own behalf except certain limited situations. You got to go through a committee. They do all those things. It's only within a certain time frame. So, but we're on it. We're on it. As of tomorrow, there'll be letters going out. So we'll be running for re-election again. And again, I'm going to stay in the criminal division. I love doing what I'm doing. And I'm going to take some questions because usually that's the best way to go. And the most interesting thing is to answer questions you all have. I saw him first. So in the back, and then I'll come back up here. Yes, sir.
You explain to us what you mean by the jury of the defendant's peers.
Okay. Well, that's an excellent topic. In fact, a question. What is amazing to me is the citizens that come in. And, you know, any of you that have jury duty, I think the typical response when you get the summons in the mail is you don't want to do, you're too busy, you really don't want to go down and serve. I can't tell you how many jurors see me in a grocery store or see me because, you know, we have the smallest big city in America here. Right, you know that. And so they'll come up and say, I was a juror in your case. And I tell you, I didn't want to do that, but I was so glad after I did it that I did it. Because I can only emphasize to them over and over again how important it is, and our system doesn't work without them. The way we select juries, you know, in a murder case, I may call 40 potential jurors up, and then I question them, the lawyers question them. If they have some prejudice or some other issue that is so overwhelming that they get excused for what they call cause. They get challenged for cause and excused. And then there's a number of what they call peremptory challenges, and that's how you get that panel down to the size of 12. And if you have an alternate, 13, or if you have two alternates, 14. You always have to have one alternate that will try the case. So that process of what they call voir dire examination, how you pick the jury, is really a critical part. And you'll have some jurors that sit out in the gallery that could be called up if needed, that never get called up. And I try to emphasize to them, I know it's boring to sit back there. I know you think you're not serving, you're not doing much, but you are. And so that's how we get down to a jury. Now, the second thing that amazes me is they have to come in, and it's not TV, and it's not movies. They've got to see things like this little girl yesterday testifying. They've got to see all the gruesome photographs. And that's always a big issue in any trial. The defense obviously doesn't want a bunch of gruesome photographs shown to the jury. So I've got a rule on each photograph. Is it overly prejudicial or not? But our appellate court has basically said, listen, gruesome crimes make for gruesome facts and make for gruesome photos. And there's no way around that. And they are relevant because they show the wounds, they show the medical examiner's results, whatever. So you have to rule on those. But when we're done with jury trials, after they've seen all these terrible things they don't typically see, it's very emotional for a lot of them. There's a lot of juror stress. I even wrote an article about it. And I don't know what to do quite about it, but there is. And so I always meet with them off the record, after the verdict, informally, and it's kind of almost like a debriefing, letting the air out, and I think they love it. And they get to ask questions that they have, because they always have some questions. There's always a question in every trial. I don't know if I'm answering your question or not, or what you were trying to get to, but go ahead.
The verdict itself seems to say that the jurors should be like the defendant.
Yeah, I mean, our system is a jury of your peers, right?
Yeah.
And I'll say, African Americans, for example, there's special rules there that might apply if you're an African American defendant. There is rules that if the prosecution starts to excuse through their peremptory challenges, or even through their challenges for cause, if they start to excuse African Americans and it can be shown it's kind of a systemic excusal, then they do what they call a Batson challenge. The defense does, and that basically says, hey, judge, listen, they are systematically excusing all the African Americans on this jury. And they've got to show a race-neutral reason to do that. So this gets a little bit complicated. But no, the jury of your peers, it's a really excellent question. And the system is the best that man's come up with. I tell the jurors that too. No system's perfect, but I guarantee you, it's all the best in this world. You know, it's not perfect, but it's the best we have. And what I have also found is people like yourselves that sit on juries are very serious about it. And they pay very close attention, not always, but 95% of them are. They always pay close attention, they take notes, they care. And that's why you see when they come back out, they don't like sending a 20-year-old kid to prison for life or life without parole. They don't like doing it. You know, you can read the paper and get outraged at crime, and I'm outraged at crime. And you can do all these things, but when you sit in that box and across from you is this 20-year-old, and your decision is life without parole or life. You know, it's not an easy decision. As mad as you might be about crime and mad, you know, how you feel about it and all this and that, you're still sitting there in this room, and it kind of changes, I think, your perspective. So it's emotional. They'll do it. I was telling our group yesterday, the toughest jurors I've seen are retired teachers, particularly women, and I'm not being discriminatory, particularly, I'm just telling you, this is just an observation. And I was laughing yesterday with everybody because it's true. They're as tough as nails. And I think it's because they've heard every excuse in the book already. And then, you know, listen, no. I see that, no, don't even try to tell me that. No. So I've been through that before. Yes, sir, Dave.
Bill, in light of the information about the jurors, I don't understand how many times can they keep trying this former police officer and getting hung juries? How long can that go? Is there a limit?
There's not a legal limit on it. It's really the DA's discretionary decision. I saw Judge Holmes, my courtroom deputy had got married, and so as a judge, you get to preside over weddings. And so he asked me to do his wedding Sunday. And so Sunday afternoon, I did his wedding, and Judge Holmes, who's presiding over the Kepler trial, was there. And I asked her that same question, Dave, and basically I said, you know, I've been around this courthouse since 1983, and I don't remember any case being tried this many times. And she said, Bill, I don't think it's ever been done in the country.
Ooh, wow.
She may know more than I know. That's what she said. And I think she's right, because I think I've heard that before also, as a matter of fact. Okay. Yes.
Thank you. Can you address the law? And I think I'm going to get the name right. In Deontay Jones' case.
Deontay Green.
The law of it. Green, right, Green. Not the facts of it, but the law of it. And I think the community's question is basically, why was that young man still on the street?
Right. Yeah, I think I don't have all the answers on that by any stretch, and I certainly would not ever, and I'm not going to have that case. I probably ought to be careful in talking about it. It was assigned to Judge Greeno, my office mate. She's a relatively new judge. She was appointed by Governor Fallon about, 6 to 9 months. She's very smart. She's a hard worker. She tries to get things right, so I think she'll do a good job. But if she recused or something, it could then go to me. So I do have to be really careful about it. I don't really have an answer as to what happened. I can tell you a little bit about the system, because we had this question yesterday about youthful offenders. And back when I started with David Moss in juvenile court, it was fairly simple. If you were under 18, you committed a crime, you were a juvenile delinquent, you went to juvenile court, it's all confidential, it's all handled out there. And if you were bad, though, or had several offenses, they could certify you as an adult, and that was a whole process with a psych eval, et cetera, to determine whether they should be an adult. It was pretty simple. That was in the late 80s. So over the years, the legislature has changed it, and added something called youthful offenders, which you heard our DA talk about on Pat Campbell's show the other day. And I have to deal with youthful offenders. What that is if you're 15, 16, 17, and you commit first-degree murder, you're an adult. And if the defense attorney wants to make you something less than an adult, like a YO, youthful offender, or juvenile, they've got to file paperwork to do that. But you automatically start off as an adult. If you're 15, 16, or 17, you commit second-degree murder, robbery with firearm, shooting with intent to kill, you name it, you're charged as a youthful offender. And what that means, and what Mr. Kunstlein was talking about is very accurate, is that this guy apparently did not fall in burglary is not one of those cases. It's the most violent crimes, except for murder. It's a laundry list. And so what I have to deal with, though, is this very precarious situation where they're 16 and 17, and the whole idea of youthful offenders is to get them treatment. So that when they turn 18 years, here's the problem. It takes a year and a half for these kids allegedly to complete these programs, right? All right. They usually don't have a full year and a half left before they turn 18 years, 5 months. So they're coming back, they have to come back before the judge. And you're sitting there going, well, he's 2/3 of the way through the program. He is, his crimes are pretty bad. He's done pretty well in the program, though. See, what kind of decision is that you have? And you know when your kid gets a felony conviction, his life is pretty much not over, but it's very difficult, as you all know, to have a good life and get good jobs and felony convictions. So you try to cut them a break. But I'm going to tell you my experience is, by giving them, say, a defer. Okay, now I'm going to put you on a 5-year defer. You're 18 years, 5 months. And I'm giving you this one shot. We've really gotten 2 already, or 3. But I've been let down every time so far. Every single time. And I did see a guy on the news the other night who was talking about, these kids that go to these youthful offender treatment and they get out. And they go right back into the neighborhood and talk about how I love being there for a year and a half. 3 meals and it was fun. We played basketball and didn't do much. And now I'm right back and I'm getting ready to do just exactly hanging out with the gangs, shooting people, shooting people, breaking into people's homes, et cetera, et cetera. So it's a really tough area, and the Court of Criminal Appeals is very sensitive to it. If we don't give kids a chance, they will reverse it right back down to us, and it happens a lot. So we have to weigh all these different things and try to protect the public, and at the same time. So I'm not a huge fan, quite frankly, of youth offender. I like the old system was simple, and I did it. And the kid was a bad kid, you filed for certification, and you could hold him in jail until that decision was made to certify him as adult or not. So, yes. Yes, sir.
In this morning's paper, on the front page, it referred to this defense attorney, and maybe this has been answered. Maybe the defense attorney is stacking the jury. What's the responsibility of a defense attorney?
Oh, you're talking about the
And what kind would you want?
Well, I don't know. I haven't read that, and no offense against the Tulsa Roll, we don't take it at home. My wife canceled the subscription when I was mayor. I'll let you figure out why.
Amen.
So anyway, so I will read online from time to time. But they weren't very kind to me, but they still aren't, quite frankly. But stacking the jury. That's just an allegation. I mean, no, the job of a defense attorney is to try to get the best jury for his client. And so they do play a lot of, not games, but they do play a lot of strategic roles in terms of trying to get people. That's why they act in their background. I mean, you don't want a law enforcement, if somebody is a police officer, they cannot be a juror in a criminal case. So they're automatically excluded.
O'Carroll was striking African Americans. That's what the...
Yeah, and that case has a lot of that going on, just because the victim was, African American, and then, of course, Mr. Kepler was a Caucasian. So there's a lot going back and forth on that issue, on the race issue.
I'll save my question another time.
Okay, great. Is it time? All right. Thank you all so much. I'm sorry I have to run.